Hello everyone. Let us look into the provisions of execution of decrees in the Civil Procedure Code, which is comprised in Order 21 about courts which may execute decrees. What is the meaning of execution? It means giving effect to the judgment or order of a court of justice, or it is the enforcement of decrees and orders by the process of the court, so that the decree holder will be able to realize the fruits of the decree. Now, under section 37, the meaning of court passing a decree, it says that it includes the court of first instance which actually passed the decree. Then in case of appellate decree, the court of first instance in that case. Thirdly, where the court of first instance has ceased to exist, then at that time of execution, whichever court would have the jurisdiction to try the suit. Then where the court of first instance has not having jurisdiction at that date, it has ceased to have jurisdiction to execute, then the court which at the time of the execution would have had jurisdiction to try the suit, that is the court passing a decree. Under section 38, which are the courts by which the decrees may be executed? First of all, the decree can be executed by a court which has actually passed the decree or to which the court sends for execution. Section 37 has an explanation which speaks about jurisdiction of court of first instance, that is, the court of first instance does not cease to have jurisdiction to execute a decree merely on the ground that after the institution of the suit or at the time of the execution, after the institution of the suit in which the decree was passed or after the passing the decree, any area which was there in the jurisdiction of that court earlier has been transferred to the jurisdiction of any other court. So, in such case, that other court to which that area has been transferred, that court also shall have jurisdiction to execute the decree along with the court which has passed the decree, if at the time of making the application that court would have jurisdiction to try that suit. This is the explanation given to section 37. Now, let us illustrate this. In the case of Merla Ramanna versus Nalaparaju, here suppose court A passes a decree, then part of the area within jurisdiction of this court A, it is transferred to court B. If the transferee court had no inherent lack of jurisdiction, that is a condition, when it is transferred, that court which has to which it is transferred should not have inherent lack of jurisdiction. In this case, both the courts A and B, that is the A which has passed the decree and B where it has been transferred, both would be competent to entertain an application for execution. This is the case which has been decided, and this is the principle in this. Now, let us look at section 39 relating to transfer of decree. A court which passed the decree, as we said, is the court which will execute it primarily, but for some conditions it may send the decree to another court for execution. First of all, section 39 subclause 1 says that it can be done by the decree holder by applying to the court, he can apply for execution. Secondly, the court itself suo motu can send it for execution to another court under section 39 subclause 2. Now, what are the conditions in which it can send? First of all, suppose the judgment debtor is voluntarily residing or carrying on business or personally working for gain within a local limits of jurisdiction of some other court, not the court which has passed the decree, then it can transfer. Secondly, that judgment debtor has property in this particular area, but he does not have property which is sufficient to satisfy the decree within that court jurisdiction, but he has property within the jurisdiction of some other court, then it can be transferred. Then the decree, if it directs that the sale or delivery of immobile property which is situated outside this jurisdiction of that court, that other court, then in such cases it will be, because the court cannot have jurisdiction to direct the sale or to actually execute the sale, it will be transferred to that court which has jurisdiction in that matter. Fourthly, the court which passes the decree, it considers it necessary to transfer or necessary to send that particular decree to other court for any reason which may be recorded in writing by that court, that that decree should be executed by that other court. In all these conditions, it can send it to another court. There was an amendment in 1976 which has clarified the point. It says that the transferee court to which this decree is to be transferred must have pecuniary jurisdiction to deal with that suit in which the decree was passed, then only it can be sent. Whether transfer is a substantive right, whether if the court can transfer and it has, see, suppose the decree asks for a transfer and the court does not transfer, the decree holder does not have a vested right or a substantive right to get it transferred to another court. This was stated in Mahadev Prasad Singh, said that the right to make an application is merely a procedure. It is not that he has a right to have the transfer done in that particular place where he wants. Looking into section 39 subclause 4, as we said, a court passing the decree has no power to execute such decree against a person or property outside the local limits of its territorial jurisdiction. Whenever there is a property and it is in some other court's jurisdiction, then the court which passes the decree cannot execute the decree against that particular person or property outside its limits. That is stated in the Amendment Act 2002 in section 39 subclause 4. It has been inserted. Next, we will look into the section 40, which speaks about transfer of decree to court in another state. Where it is sent for execution in another state, then it will be sent to the court there, which will be executed by that court as prescribed by rules in force in that state, not in the original state. Let us look into the result of execution proceedings, what has to be certified. The section 41 says that once the court sends the decree, the court to which a decree is sent for execution shall certify to this court which has passed it, that is, it will certify that the execution has been done. Or if the former court fails to execute the same, or if it does not, for some circumstances which it could not execute, then it will also certify and notify the circumstances by which it could not bring about the execution for the failure of it to execute the decree. This is section 41. Now, let us look into the execution of foreign decrees in India. Section 43 says that the Indian courts have power to execute the decrees passed by Indian courts to which the provision of the code do not apply. There are several provisions where, for example, when we look into the revenue courts or when we look into special courts for which a special law, the civil procedure code, may not apply to that particular court. For that also, whatever decrees are passed by such courts, the Indian courts have power to execute them. And also courts situated outside India, which are established by the authority of the central government, even those courts, if they have passed a decree, that can be executed by the Indian courts. Section 44 says that the revenue courts to which the code does not apply, their decrees also can be executed by the Indian courts. And section 41A says that superior courts of any reciprocating territory, if they pass any decree, that also can be executed by the Indian courts. Now, what is the question? What is the reciprocating territory? Reciprocating territory means any country or territory outside India which the central government may, by notification in the official gazette, declare to be a reciprocating territory for the purposes of this section. This is the actual definition of the reciprocating territory according to the CPC. Now, when we speak about execution of Indian decrees in foreign territory, section 45 speaks about this. It says that a court in any state can send a decree, that is vice versa, because just as we can send a decree for execution outside, any state, if a court has passed a decree, it can send a decree for execution to any court. See, those courts have to be notified in the official gazette declaring that this section will apply to these courts. In such cases, that can be, those decrees can be sent to those courts which have been established by the central government outside India. That is section 45. Now, decrees can be executed at more than one place also. The code does not prevent a decree holder from executing any decree at two or more places if it is necessary. But in Lakshman Hari versus V.G. Virkar, it has stated that it is not just because of the whims and fancies of the judgment debtor that it should be done. Such power should be exercised sparingly in exceptional cases and after issuing notice to the judgment debtor. If at all it has to be executed in some other place along with this place where the decree was passed. The Order 21 Rule 6 speaks about the procedure which is followed when the decree is sent to another court. The court, according to Rule 6, the court which passed the decree will send the decree to that court, that is to other court, along with a copy of the decree. Secondly, a certificate of non-satisfaction or part satisfaction of the decree. Thirdly, a copy of an order to ask the court to execute the decree. And finally, if that order has not been passed, then a certificate saying that the execution of the decree should be done. This is Rule 6. Now, Rule 7 speaks about what happens when the decree is sent to another court. There, the court which is executing the decree, when it receives these copies and all the certificates as we have just now said, then it shall first of all cause that to be filed. It will not ask for any further proof. It does not go behind the decree. Without any further proof, it causes the same to be filed. Rule 8 says that suppose the court to which the decree is sent is a district court. The district court may execute it itself, or it has power to transfer it to any subordinate court of competent jurisdiction under that district court. Where such court is a high court, then the decree shall be executed as if it has been passed by that high court in exercise of its original jurisdiction. Order 21 Rule 3 says that when the land to which is the subject matter and to which the execution is directed, it is situated in more than one jurisdiction. It forms one estate in one place or some other part of that estate is in the local limits of the jurisdiction of two or more courts. Then in that case, any one of such courts can attach, they can sell the entire estate, though it is only a part of which is in their jurisdiction, they can sell the entire estate or tenure. That is Rule 3 of Order 21. And what is the mode of transfer? The mode of transfer is specified in Rule 5. The court which passed such decree can send the decree directly to such other court, whether or not that court is situated in the same state. But when the court is sent for execution, that court to which it is sent, if it has no jurisdiction to execute the decree, then that has the power to send it to the court having such jurisdiction. So that is the mode of transfer to another court. When a court which has passed a decree has transferred it to some other court which is a competent court, then once it has passed the decree, it has transferred its execution powers also. Then it does not have jurisdiction to execute the decree. This should not be confused with what I said earlier, that the court continues to have jurisdiction. The court continues to have jurisdiction because the decree, if it is not executed, this court still has the powers. But once it transfers it to other court, then the power to execute is also transferred to that other court and the earlier court ceases to have jurisdiction. What are the powers of the transferee court? Once the decree is transferred for execution to another court, that transferee court shall have all the powers which it has or which it would have had if it would have passed it itself. The transferee court, what are these powers actually? The transferee court will decide all questions which arise in the execution proceedings, and it goes on until it certifies to the transferor court that the decree has been executed. This is stated in Mahadev Prasad Singh once again versus Ram Lochan. So all the powers which are there to decide all the questions which arise in the execution proceedings are in the hands of the transferee court. Now, what are the powers of the executing court? Section 42 subclause 1 says that the court which executes the decree will have all the powers as if it has passed the decree itself, and any person who disobeys the decree or any person who obstructs the execution of the decree shall also be punishable by that court itself as if it has passed the decree itself. Section 42 subclause 2 says that the powers include all these. First of all, to send the decree for execution to another court under section 39, to execute the decree against the legal representative if the judgment debtor is deceased under section 50, then it has a power to order attachment of a decree also. All these powers are there. What are the limitations? The limitation is that it cannot exercise the powers which could only be the matters which can be taken up by the court which has passed the decree. For example, it cannot go into the substantive right of the parties. It is only relating to procedure to be followed in execution. It cannot question the rightness or wrongness of the decree. It cannot question what happened before the court which has passed the decree. It can only procedurally it can execute the decree. It cannot convert itself into the court which has passed the decree, though it has all the powers to look into the execution, though it has all the powers to execute the decree. It cannot become the court which has passed the decree and go into the rightness or wrongness of the decree. So, looking into the points which we have discussed, execution of decrees can be made either by the court which passed it or to the court to which it has sent for the execution, and the provisions relating to all these things, that is transfer for execution of a decree, conditions for transfer, powers of executing court, all this need to be read together. Section 37 to 45 provide for the machinery to execute decrees passed by the courts, and a decree must be executed ensuring that the defendant gives the plaintiff the very thing that the decree directs and nothing more or nothing less. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.